Good morning, everybody. Good morning. We are live with court in Massachusetts for the Karen Read trial. Let me just share the screen here. They just said yay, 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 yay. And okay, here we go. We are live.
Jackson. Good morning, Your Honor. Elizabeth Little, also on behalf
Good morning, Bev. Hello.
Good morning, Your Honor. Robert Alessi for Ms. Reed.
Mr. Bessie.
Good morning, Your Honor. David Kennedy for Karen.
Good morning, Mr. Kennedy.
Yes. Good morning, indeed.
All right. So we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ACCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under Doggett grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today.
Sounds like it's going to be a long day today. Please let me know how the sound is. Can you guys hear?
Tapes.
Well.
Police station video. So that's the order that makes sense to me to finish up what we already had scheduled last week. Before we do anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You know that. Do you understand that, Mr. Yannetti?
Oh, please.
I do, Your Honor.
Mr. Jackson?
Of course.
Condescending is in town.
Mr. Alessi?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, this knows. So the questions that I have. Before we start, so I
Had to
want it
change
be
real
very
quick
clear. Counsel
the feed.
knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations,
Wow.
you speak for the entire defense team. You know that. Do you understand that, Mr.
Look at how
Chairman?
condescending she starts
Mr.
this
Jackson?
hearing. When you make a representation or misrepresentation, do you understand that? Do you understand that?
Each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Alessi, that you said were welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called it. Could you stand, please? Because I can't hear you.
It was a pause email.
Sure, go ahead.
Thank you. I didn't want to stand when you were talking.
You could stand.
Here he
All right.
goes. Hi,
So
Leslie.
the
Good morning.
pause email is you call it. So first of all,
Let's
have that
pause
Wednesday,
all
March
communications
20th.
for now.
2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation
Pause.
until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that
Can
that
I talk?
invoice was
Can I talk?
paid Sunday night before February 18th. I'm going to repeat that. I learned,
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through.
Like I'm trying to
And
be
when I got to
organized,
the
Your Honor.
invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ACA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
All right, I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I marked them as exhibits. I didn't do that last time.
Of course you did.
And I had marked, Mr. Brennan has agreed to them going, may I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1. So I picked off on 2 and worked it out before. What would you like me to do with each, Your Honor?
You can hand them to the court officer, who'll hand them to the.
Oh, he's so sweet.
Well, there you are. Thank you.
He's
Thank
so
you, Your Honor.
sweet. How can you not like him?
Have you concluded what you?
Yes, but let's.
Okay.
But she came in hot. She's aggressive and condescending from the beginning towards the defense.
All right, so let's go on to your, do the Commonwealth want to add anything?
Oh, here we go. Oh, yeah, because you're siding with us. We're good.
I don't know. 499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby,
It's denied.
and I've read it 2 weeks ago when it came in, Mr. Leslie. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to
time.
it. Thank you.
Let's go, Alessia. Take a deep breath, okay?
May it please the court.
The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified.
That's what she's going to say.
On the cause of the wounds to the decedent.
Because for Dr. Russell, she wanted her to be a doctor.
Then the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm.
What is his profession then?
It almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document
Where's
that it
Chloe?
was.
Where's
There's no
Chloe? Where's Chloe?
documentation of that, but let's assume hypothetically it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the
Based on the
measurements
photographs?
and distance of the wounds on the right arm.
No.
Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a
Where's the
dog.
proof it was
And this
Chloe?
dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object.
How? How does he
It
know?
just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study. He doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something.
To the actual wounds, not a
something
picture.
is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to.
Of course you do. Of course
The
you
overlay
do.
method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part.
He used
of
a
what is,
picture.
even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable.
But he's like, I know dogs' behaviors.
What he also does
So do I.
in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex,
Dr. Russell.
that is going
Medical
to make those wounds
doctor.
approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion, it's a methodology. So, and again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred, so it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My.
What?
She had, I think, 31 footnotes in her report.
She has all the
The one who
credentials. She has done
Entire
everything.
opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin, when there's any pressure, particularly with a bite, it moves, it tingles, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do?
By
went
who?
and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his, I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods and reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis. first full paragraph, where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify.
Wow. Wow.
If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with.
Wow.
Dr.
Yeah,
Russell.
because Dr. Russell
So I
is the
respectfully
best
request
expert
that
there
he be
has ever
excluded.
been.
There's no need for a Daubert hearing.
She has all the
Plain
qualifications.
on the papers, and it's not
And it
something
was a close
that
call,
is
you know.
curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close. And I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
Who calls himself a behavioralist, by the way. Is she gonna say something now? Prosecution.
Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object. Is he? Are you planning on bringing that in?
I wouldn't ask him to do that, no.
But he said it.
So he-
Yeah.
Yes.
But he's still not a medical doctor. He still didn't show how he came with his findings. He compared it to a picture.
Mr. Alisi tries to
Tries to.
point out differences between Dr. Russell
The
and
shade.
Dr. Crosby, and there's always going to be differences between experts.
Yeah.
One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had
Okay.
before this case. And so in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing.
How do we
And
know
that
it's
was
Chloe?
provided
How do
to
we
the
know
defense
it's Chloe?
prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark
So
analysis.
his reliance is based on
The list
books.
is comprehensive, variable mechanisms of
I
dog-related
can get
deaths,
books.
life-threatening dog attacks, a devastating combination of penetrating
But
and
who
blunt
wrote
injuries,
these books? Who are the
fatal and
people who are
near-fatal animal
actually?
bite injuries,
Well-
on and on.
Sorry.
These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal
'Cause I
court
said so.
before this case, but also because of his studies and his education.
His
It seems as
education, let's
though
see, what's the
Attorney Lisi
education?
is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical
But
doctor.
she said so.
There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine,
All
completed
right.
coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks.
But
if
in
they
this
are
case,
dog
did he
wounds,
go to
and
the
if they can be
autopsy?
attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he hasn't, I can supplement the autopsies he's been to. And I
What
can
about
also
this
supplement,
case? We are
specific
interested in
cases where he's
his-
qualified. He
this
has listed a number
bite
of
marks.
cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They
So
have-
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which.
How do we know it was Chloe?
demonstrate
Do you have
that
DNA?
the
Do you have
distance
a
of those,
film?
Wounds are
How do we
not
know?
anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information?
Right.
to the defense?
We
Exactly.
have, and we can provide that as a supplement to the court. the
Please.
Verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not
I
in this
have
package.
that, I think that's attached here, I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that. to the
Yeah, please, that would be nice. It would be nice for us to have everything, all the
So
discovery.
I'll supplement those two different items for the court's reference.
Please, I want to see
In
DNA.
addition to his experience, he was chief of animal care protective services of the city of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the animal control division manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well-recognized in the field. He has employment in other projects other than his business. It includes a research associate Canine Brain Project, 2023 to current. It's associated with Harvard University. Duties
Okay.
include the investigation and documentation of dog bite and related human fatalities. Also, division management consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now,
Fatalities.
Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that
Incisors.
he has measured the distance of all of those teeth.
But use the picture to
specifically.
measure it.
Then in
That
his
doesn't make
methodology,
sense.
He outlines each group of lesions, specifically lesion group 1,
Sure.
lesion group 2.
But he's using a
And then he goes into an
picture.
analysis of the different groups of lesions.
Am I the only
He
one
explains why
confused?
they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Alisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA.
Like from bacon?
And so while there are different methods,
From like
some of
dog
the things
treats?
that
Pig
Attorney Lisi
DNA?
spoke about dentition deal with human biting, not dog biting. His methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case.
Okay, she's gonna let
He
him
did a
in.
thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report. Has
What's
not wavered,
always? How
and
long
he
is
Highly
always?
qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
All right, Mr. Alessi, any follow-up?
Thank you, Your Honor. Thank you.
Who is that?
The Commonwealth did not address in its presentation, you heard one probative, legal or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important, you can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2, Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now,
Hold on, so that's
Yes.
exhibit 1 and 4.
yes, exactly.
Give me a minute, just put them back together. Next, so what page?
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
He's so respectful. Look at him. Just waiting for the judge to find it
Okay.
So
and go.
he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies.
Okay.
My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc.
My point exactly. What about Mr. Keefe's injuries?
What I want Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the dog bite, excuse me, the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Dalbert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard, but what is it that he is participating in Harvard in? And this was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. he does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert
What
inquiry.
facts?
You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr.
acceptable.
Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end?
So
No
thoroughly
footnotes
criticized
in his
by the
study.
judge, by the way.
I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify
His
with regard
methodology
to
is just an orphan.
whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Anything else, Mr. Brennan?
Briefly.
It's never briefly, by the way. Now let's take
On
some
page 6 and
things
7,
at the
Dr. Crosby
defense.
offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be
this
intellectually
sucks.
honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent.
We're
with
not talking about
the
Dr.
testimony
Russell. We're
or the
talking about your
mannerisms of the
expert.
way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter of somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay.
Let's
So
see what she's
before we
gonna
move on
do.
to the next motion, the next motion
Oh,
was
she's not gonna
it was
decide.
filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your
All
Honor.
right, so,
It's me all the way, Your Honor. So Robert Gilman is a meteorologist. I can't say that.
and this is.
And he's gonna testify about the condition of the ground where John O'Keefe's body was found. Let's see what the opposition is from the
May it please the
defense.
court,
You are pleasing.
Mr. Gilman, a
Thank you.
meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his qualifications, his qualifications to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So his
opinion is somebody else's opinion?
Is hard as a rock, I believe. I'm looking for it.
So I'm sorry, there were a couple of exhibits attached to your affidavit, Mr. Leslie.
Yes.
So one's exhibit 1, I don't see any.
I'm sorry, Your Honor. It's Exhibit 1.
Okay.
It's his February 3rd, 2025.
There's no as hard as a rock.
certified weather statement.
Therefore, the
That
dog
is
didn't
it.
bite Mr.
And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
no, his report is Exhibit 1. It does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that 1, he's qualified, and 2, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
Right, I'll hear you.
Thank you.
The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed. Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock. And state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Would you say that, Mr. Lessing?
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance in shear strength.
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
Happy to provide it, Your Honor.
He's so
Do you
cute.
want to provide a copy to Commonwealth as well?
No, I
I'd be
don't.
pleased to provide a copy to the Commonwealth.
All right, so I'll
Just
take
you,
this
Your
as a-
Honor. I don't like these people. Okay, so she's probably gonna say yes to this one,
So how long do each of you need to get me what you said you would get me?
but we want to know about Alan
Articles,
Jackson. We
and
want to
the
know what you're gonna say about
Okay.
the
The basis
defense
and the qualifications
judge.
of Dr. Crosby,
I can have that to you today.
great, okay. And those articles, Mr. Leslie, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to
Go
find them
look
and read
for
them,
it.
that's fine. If you just. give me the
Everything you
links, I
just
can do it.
cited,
I'll
let's
get you the
back it up,
articles,
back it up.
Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. That'll save you from having to print the articles.
Let me hand it to the court officer.
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Lissy? Did co-counsel have copies?
Oh, no, the co-counsel doesn't have any of this, Your Honor. I just need to black out something here that's,
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your Honor.
Now
Thank
we're
you.
there, we'll see to it, Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions.
That's it.
This
That's why we're
involves
here today.
Transcript that I've read, I've listened to the actual recording. Maybe it makes sense to take a 15-20-minute recess.
Come on, Judge.
Okay.
Come on.
I'm
I
going to play portions first. Or
boo.
not, the flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, I'm gonna see Councilman.
Quiet, please, so direct.
What did she say? 10 minutes? Ooh, 10 minutes break. That's okay. Don't be upset. We're going to do stuff while she is on break. We're definitely going to do stuff. Let me just post here that we're going to do stuff when she comes right back. So this is why we're here. Good morning, everybody. It's great to see you again. Welcome back to the trial that never ends, the Karen Read trial. Yes, yes, yes. I hope that she is able to have a fair and balanced trial, that we don't get the ARCA testimony out, that we don't get Dr. Russell out, that we're able to have as much evidence as we possibly can so that the jury can make a fair determination. Today is March 4th. So far, we heard a little bit about two motions. The first motion was a motion to exclude Dr. James Crosby, who apparently he's a retired sheriff, lieutenant, and he was consulted by the defense regarding the marks on Mr. John O'Keefe's, the deceased, his arms, and we all seen that picture where it looks like he had dog bite marks. And there's a conspiracy out there saying that Chloe, the German Shepherd that belonged to Brian Albert, no longer belongs to Brian Albert, that Chloe bit John O'Keefe, and that started the whole process of him showing up deceased on Brian Albert's lawn. We don't know what happened. That's what we're trying to find out with the trial. But the defense is saying, listen, Dr. James Crosby cannot testify about the bite marks because he's not a medical doctor. And also his methodology was flawed because he apparently says he took measurement of Chloe's teeth in like real time. So he says he saw Chloe the dog, and we haven't seen Chloe the dog. We don't know where Chloe the dog is, has been, or will be. There are speculations out there on the internets and the interwebs that say that Chloe the dog is even dead. Huh, no, whisper, don't listen to this. My little dog is taking a nap here on my lap. And also that he took those measurements from supposedly Chloe's dental marks and her structure, and he compared it to the picture of John O'Keefe's arm. So that to me doesn't make any sense, right? Because he didn't do it in an autopsy. He's not a medical doctor, so we don't have proof that it was actually Chloe. How do we know? Did you film it? Do you have a DNA showing that this is Chloe? Because nobody has heard from Chloe. And also he says that he is an expert in dogs' behaviors, but he doesn't really have any, licenses or anything to back up this type of experience that he's claiming to have. I have a lot of experience with dog behaviors because I go to the dog park all the time. Does that mean I'm an expert and I can tell you that behavior is okay or not for this professional opinion? I don't know. So we don't know what Judge Bev's going to do with that motion. That motion was to defense's motion to exclude his testimony completely. They just want to have Dr. Russell in. And then the second motion is a motion, again, another motion from the defense to exclude James Crosby, who is a meteorologist. Okay, so he deals with the weather, all right? And he's supposed to come in to tell us about the snow that day because we didn't hear enough about the snow. It was snowing, and we know it was snowing. So the defense doesn't want this guy to come in either. So what I want to do right now, real quick, is go back to the video with Judge Bev apparently stopped abruptly the testimony, pre-trial motions that were going on to talk about these claims, right? The Commonwealth is saying the defense had a relationship with the ARCA experts before the trial, before they had the opportunity to question them, and that they never turned in what they actually had as far as discovery, that they knew what the ARCA experts were going to say, but they just never turned in to the Commonwealth. So they want to exclude the ARCA experts, and they also want sanctions. They want to have a possibility of Alan Jackson removed from the case, which is insane. Like, if Judge Bev does that, it's absolutely insanity. It doesn't look good for her at all. She has a complete bias that we documented here on this channel go check the Karen Reed playlist and all the videos that we clipped with Judge Beth and how she treated Karen Reed and her defense team during the previous trial, pre-trial motions, which was absolutely aggressive, condescending, rude. She would constantly interrupt them. She would treat them very badly. And then when it comes to the Commonwealth, she treated them with respect. So now apparently we have another issue, which is this new, wait, I think they're coming back. Are they coming back already? Wow, they're coming back already. Okay, all right, we'll talk about this later then. Let's see, this is the big one about the sanctions. Let me put myself a little bit smaller. This is the big one, guys. We want to know what the judge is going to say about this. Yanette is like, just relax. Yikes. Wait, was this not anything? Oh, this was not anything. Okay, what was that? Hello, court? Nope. Okay, so we are gonna go back to the day where she abruptly ended the hearing. And I'm curious because I did not watch that yet. So this is gonna be fun. All right, let's see what happened that day. What is everybody talking about? She looks so mad.
All right. So the Commonwealth just provided the court with information that causes me grave concern.
Grave concern.
The implications of that information may have profound effects on this defense and defense counsel.
Ooh.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock.
Okay. So let's talk a little bit about body language here. Why not, right? We are indeed a body language channel. Now, her voice, okay, just take notice about her breath and like how much she has inside of her that she's citing more than normal. She's just like, we're gonna pause here after what I just heard. And then she says the words profound, grave, and then that have to do with the defense counsel. So she's implying something here. Just, it's not frustration that I feel. I feel like she's angry. But let's keep going and see what else we can notice here.
O'clock in the morning, you can tell me now if that is impossible for you. And
Chinjot.
Mr. Brennan, where the federal authorities.
Chinjot is when you are showing aggression towards somebody. You just go like, you know what? You want to fight or what? So she's just like, she was asking a question about scheduling and then she continues breathing. And then she stops and she's like, so she's just very angry.
Have been kind enough in the past to allow me to have copies of everything. Would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology, I think, Your Honor.
So now this is the prosecutor responding to her. Now, he made some serious, savage allegations against the defense counsel. He's saying the defense counsel knowingly hid stuffs. He's saying that the defense counsel had a previous relationship with the ARCA experts. The defense counsel talked to the experts about their testimony, that they knew what they were going to testify. And this is all stuff that the defense is saying never happened. The only thing they talked about was scheduling, their experience. There was an email about a possible letter of engagement, but that was never signed. It was paused because the federal court told them that they couldn't have any communications regarding the case. So she receives this information from the prosecution saying the defense knew a lot. They just never provided discovery. They knowingly hid facts from us. And the judge believed the prosecution. And now the judge is like, okay, so can you also send me some proof about what you're saying the federal court, provided you? So she's just very angry, but without facts. Based on what I'm observing here, she's just going by what the prosecution told her.
Your Honor should be aware of. If I could add that right now, it would take me
Okay.
less than a minute.
Ooh.
The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th.
Wait. Let me go back a second. Let me go back 1 second, because he's saying the federal, the attorney's office changed their position regarding information if either party wants to engage. Okay, hold on. Let me go back a little bit more.
Without any prompting, on February 6, 2025, the defense and the prosecution received an email
Okay.
from the U.S. Attorney's Office saying
So the U.S. Attorney's Office sent both parties an email.
that the contract had ended with the ARCA experts
Okay.
and that if either party wanted to engage, the original materials are still protected.
So if either party wanted to engage, the original materials are still protected. So does that mean they can engage with the ARCA experts or not? Because the ARCA experts contract ended, but the materials are still protected. Okay.
This was a change in position about whether a party could engage.
Wait. This was a change of position whether a party could engage. No, because the materials are still protected.
On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent.
Well, that makes a big difference. So it wasn't the U.S. Attorney's Office. It wasn't the federal government that said both parties, the contract ended, we are now can engage, but we can now engage, but the materials are protected. No, it was the defense that provided the prosecution this. Okay.
They sent us the emails and the direct examination outline. We reached out to the federal government again because.
And then we also had a direct examination outline, which was attached, I believe, to this email. So the prosecution reached out to the federal government.
I was curious about the change in position on February.
There was no change in position. Their contract ended with ARCA, but the materials were still protected. So I don't understand a change in position.
6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position.
I never heard that the parties could contact ARCA. I heard the contract with the federal government ended and the materials were still protected. That's what I heard.
To contact ARCA because that would naturally preclude the defense from retaining them. So
That's what you're trying to do. You're trying to prevent the ARCA experts, Dr. McDreamy Wolf, and the other doctor that is very highly qualified, but I forget his name, to testify. And why are you doing that, prosecution? Why are you trying to prevent these two experts from testifying? Aren't you supposed to be seeking justice? Aren't you supposed to be seeking the truth? Aren't you supposed to be fair and balanced? No, but you want to exclude stuff, right? You want to hide stuff.
we've refrained and we will not reach out to them.
Okay.
All right. So the information that was provided to you.
Oh, he feels so good about himself. Look at him. He's like, walking away like he's the, the best, whatever, I don't want to curse, the best thing in town. And I don't know. I don't know if I buy his arguments. Like, okay, let's see what she's gonna say.
Not from the federal government. I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your
All
Honor,
right, that's
is
it.
it possible to move
Oh,
it
don't talk to her, Alan Jackson. She hates you right now.
one day to the 26th instead of the 25th?
No, it's not possible.
It would have to be at 9 o'clock in the morning.
Scheduling.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant reference by
Why is he sitting here? Like, go do something with your life.
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
He doesn't want to be on Zoom.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's schedule. If we can do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
No, say no.
I'm not.
Okay, good.
Ma'am, just a moment.
Thank you.
Okay. She's like, so, what is this from the other? I'm sorry, guys. This is from the other feed that has the break going on right now, and they just beeped all over my ear. I hope that it wasn't in your ears as well. Look at this. Josh Yu is here. Hello, Josh Yu. Good to see you. What is a BOB? I hope it's nothing bad that we are not allowed to say here. I don't know. So that's what happened. The prosecution claimed a bunch of stuff, and then Judge Bev believed them without any proof, right? Without anything in writing, no copies of emails, nothing. And she's just like, okay, this is grave and profound and can affect the defense. So sure, Judge Bev, but don't you need to like have backup documentation to be able to say this type of thing? Now let's see, before that, what are his claims? Okay, no, I want to do the one from the last pretrial motion, which was, I think, last week, 6 days ago. The one where he is talking, like his last words, okay? The last words from the prosecution regarding this issue. After the defense had provided a whole outline, after the defense had provided a whole book with tabs, highlights, and proof and evidence and evidence and evidence. Let's see what is it that the prosecution responded. What were their last words regarding this issue 6 days ago before what we are waiting to hear? We're waiting to hear from the motion regarding sanctions, the Commonwealth's motions against the defense for sanctions, which could harm them as attorneys, because Alan Jackson is being invited, is being granted permission to practice in the Massachusetts court. He's not licensed in Massachusetts. So the Commonwealth is asking the court to put sanctions on him or remove him from the case. And that is so harmful because it would follow him through his entire career. And he seems like, they all seem like very professional attorneys, very stand-up people that are going to be following, their ethics, their integrity in court. I don't know about their personal lives, but in court, you're supposed to have a high standard for ethics, and you can't hide material facts. And I highly doubt that he did, but this is what the prosecution is claiming he did, and they're asking for a high punishment. So let's hear a little bit of this guy, not a fan of prosecutions in general, because I just don't think the system is fair. But let's see what it is that he said 6 days ago.
But it ignores entirely withholding this information before the first trial.
Oh, the sound is awful.
Defendant presumed innocent has a right to a fair trial, and so do the people who Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information.
Hold on, I'm gonna try to switch the feed because I can't. Trying to find one that has, okay, let me see if we're back or not. It looks like we might be back. I had to move. This is the actual live court, just so you guys know we are watching the fan. OnlyFans again. OnlyFans. We got the fan going on. And in the meantime, I'm trying to find a better video. Okay, I found a better video. Let me just go to the end. I want to see the prosecution's last words regarding this issue 6 days ago. And then that's how we end it. We are going to wait for the court to either rule. I think they're going to rule today, because what else are we here for? Are we just going to hear this whole thing again? Does he have any backup proof of anything, or is he just talking out of his butt? So here we go. Let's hear this one.
If there was any limitations to it, and I don't have a certain answer, what I'd like to do is inquire.
Please. All right, if I can have it, I'd like it. It would help guide me through this.
Yeah, let's have backup. Let's have the receipts.
Sure.
Go ahead, Yannetti. I'm sorry, Yannetti. All this is going on in your life. We love you. Okay, so let's make.
I'll need to call the United States Attorney's Office. And get an answer.
Yeah, call him. Why don't we have this stuff? Are you guys amateurs?
And so the betrayal.
Betrayal?
There was a rules of the road. There was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly, because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact,
Okay.
it's underscored, isn't it, by the emails that we received where Dr. Wolf replies in the 24 saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the board here, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses.
Right.
On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got.
Right.
Or asked, I haven't. If you can't, that's fine. so not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from
Right.
anybody in their world.
Okay, so this is what the defense said. The federal authorities do not allow me to interview anyone in their world. Okay, this is what we all got, the information that we got. This is what we believe. The prosecution saying the defense is lying. You're lying. I don't believe you. You talked to them, you interviewed them, you had a whole pre-trial preparation with them, and you never told us willingly. That's what this guy is saying about the defense.
So I have nothing. I've got a report, he's got the report, that's it. I'm going to start asking questions on the report, that's it. He can cross the report, so as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report.
Of the report,
Those are definitely questions I'm going to ask, so I've got clean hands.
right.
All right, so.
So from my understanding, ARCA had 8 reports. They had reports regarding their opinion on the federal case, okay? The defense has the report, the prosecution has the report. Both of them had the report. The defense read the report and they said, this will be beneficial to my case. I'm going to ask these guys to testify for us. The prosecution didn't want them to testify, didn't ask them to testify. But the defense is saying, we had the reports, we had their findings, but we never talked to them about their testimony. We never paid them before they testified. We never had a conversation, this is how you're going to testify or not. And this guy, the prosecution is saying, I don't believe them. They had to have a conversation with them, with the ARCA experts, and they're lying.
Reading from a transcript, as you know, there are.
And not only they're lying, but I'm asking for you, courts, for you, Judge Bev, to give them a sanction or harm them in some type of way.
Dozens of transcripts. What's the volume number? There's Dave, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
Keep going, sir. What else you got?
Contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite.
Okay.
It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it.
Thank you.
Those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, this is June 10, 2024, trial transcript 28.
Hold on one second.
Okay. Wait, we gotta go back. We'll come back to this another time.
Getting me these materials, Mr. Leslie and Mr. Ray. Thank you both. All right.
This is live.
So the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48.
Sanctions.
Mr. Leslie, do you need a minute? Did you need a minute or so?
Could I please just?
Sure.
Thank you.
Timmy?
Yes, I'm working on something.
This is what we're here for. The motion for sanction.
All right, please.
All right. I can't rise right now because Whisper's on my lap. But thanks. No. What happened? It's not me, guys. The court's still live. Still live. We're waiting for them to play. Ay, ay, ay. This is so frustrating and exciting at the same time, but I don't want anything bad to happen to the defense counsel. What is going on? I'm live. I'm live. I'm live. Come on, court. Do I have to change to law and crime? Is that what's happening? Let's change it. Okay, let's change it to law and crime. I don't know. They froze law and crime. Law and crime. Where is it? Where is it? Where is it? Come on, guys. Let's try this feed. Oh, we still have the fan. And the background noise is awful here.
We're back in session, may see you.
Oh, this sound sucks.
All right, so, Brennan, I hear you on this motion.
Go back to court TV, guys. Sorry. Let's hear it on the motion. Let's hear it. I promise I'll stop talking now. Come on, court TV. Why are you guys late? I'll give you like 5 seconds. Come on, court TV, because their sound is better. This is why I want to stay here. You guys are so late. It's not even funny. So I'm going to do law and crime, then I'll come back here in a minute. All right, let's do that. No? Come on. Come on, come on, come on. Wow. So let's go back to law and crime. And then we'll go back here in a minute to a court TV. So we'll have a little background noise.
That the court ordered the defense
Go back.
not.
This guy's starting to piss me off already. And I don't even know him that well. I don't know. Maybe the internet's just like not helping today. There you go.
Thank you. As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred.
Okay.
If
Now
there's-
he's back on court TV.
In this instance, that was the genesis for this motion.
We'll just start
Those
here.
Recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial,
Yeah, like the inverted video.
history of this case, it is important to make sure that these type of violations don't happen again.
The
It
nerve.
stands out to me
The
in
nerve.
reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness, who was not bound by a sequestration order at the time of
Which
closing,
trooper?
didn't
Trooper
want to
Proctor?
closing,
Trooper Paul?
there's no
Because your
indication
troopers kind of suck.
whatsoever that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors.
Oh, please, cry me a
And
river,
so,
sir.
not
You have
only
an
is there
inverted video.
really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We just turned it over as a text message, and notice of discovery 51, a protective order was issued, number docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules.
Stop the PR, right?
Trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless,
Right.
when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The
Right.
rest of the folks that were in that house.
Chloe,
some
the
level of
dog.
Involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness.
Don't raise your
It is
voice, sir.
specifically concerned about the credibility of witnesses. There's been a ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign.
The opinions are not in line with the reports. What? Do you have proof
In
of
addition
that?
to
Can you be
this
specific?
recent protective order violation that got attention that money couldn't buy for a party. Other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18th, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done
Facts.
to Karen Reed.
Facts.
This is,
When was that Court TV again?
I can get the date for your honor.
Why don't you have the facts?
Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real
Trooper Paul,
association or
Trooper
relevance to any
Duper,
discovery
Super
motion.
Troopers.
And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
Really?
It is closed. It is over.
What
All
happened?
those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality of fact.
Of course they are. There was a federal case. Just because there isn't anymore
I see.
doesn't stop being a fact.
That the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest,
Okay, so let's
Is
talk
that
about your sanctions
now
regarding the
trial?
inverted video, sir.
all pleadings submitted by the defense should be under seal, so the court and the Commonwealth can review them.
So you can hide
and
stuff
make
again.
any objections if there's any material that's
No.
private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media.
Are you jealous? What? They
No
have
more
the right to
statements
speak.
press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts, so that we can have a trial on.
They have a right of the First Amendment, free speech,
There should
sir.
be a gag order on all of these attorneys.
He wants a gag
Every single one of
order.
them. And the Commonwealth will not speak either.
Wow. You like to hide shit. Sorry.
Read, I'm not asking for a gag order for it.
So I say it.
And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions. And that's what I'm asking for.
Who's Jerry? Who's a fair Jerry?
Mr. Janetti, you're arguing this, you said?
Yes, Your Honor.
We miss you, Yannetti. Please come talk to us, Yannetti. He wants a gag order. He wants sanctions. He doesn't want the press anymore. He doesn't want them to have free speech. You can't talk about the case. Wait, are we getting a break now or what's going on? Is this a break? Anyways. So the prosecution comes in and talks about this email. Apparently, there is an extrajudicial statement the defense made public. And then they have a problem because the defense is giving interviews. They have a problem because the defense is outside in the stairs and there is support. And they have a problem, the defense is speaking out. But they don't have a problem in putting out an inverted video and saying this video is completely fine. And then the next day being like, well, it's fine, but it's like completely inverted. So whatever you see here on this side is supposed to be on this side, where we're actually paying attention because that's where the headlight was supposed to be broken by her car. Because apparently you guys are saying she hit Mr. O'Keefe with her car. So if that's broken, and we're looking at that side, why are the people on the other side? It's just so confusing that the fact that they are being aggressively asking for sanctions towards the defense when they themselves have committed so many, what did he call it? Violations is what he called. So while we wait here, let's go back to let's watch something fun while we're waiting, because this is what we're watching right now. We're just watching the OnlyFans, and you know what? I've had it. So let's go to one of the old videos about Judge Bev. Let's watch something fun, because why not? You know, I'm tired of this whole thing. So if you guys go here to my channel, Bianca MMM, and you subscribe, you win a prize. Just kidding. If you go to my channel and you go to playlist Karen Read, not Sarah Boone, Karen Read right here. There's so many cool videos that we have done about body language when the first trial was going on. Now look at Judge Bev's video, 5 minutes. So maybe this will be good for the break. Let's see this one. Let's watch this one.
All right, so why are we out here? All right, so why are we out here?
Forms, and as we discussed yesterday, the amendments the court indicated it would make them.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it. I said I was tired and I needed to think about it. I said I was tired and I needed to think about it.
You said before you retired and you needed to think about it because you agreed that there needs to be not guilty options for subordinate charges.
No.
Under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts. Is exactly how it always is in Massachusetts.
I think we're back.
Is exactly how it always is in Massachusetts.
Ask your question.
Okay, we're back. I'll come back to that video later. Unetti. Where is it? One second, guys. I'm sharing the screen right now. Ooh.
Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate. And I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing
that
he feels
sucks
the same
for the
way about Mr.
prosecution.
Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit.
Sure.
And while the protective order covers this communication, I will note that there's certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial,
Yeah.
again, about Karen Reed's attorneys.
Very bad opinions
So
indeed.
further information coming to light in this motion, that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I didn't. I do have concerns about my ongoing obligations, so perhaps I could have a moment silent.
What concerns? What obligations? Okay, so Yannet is saying he made a mistake, and then he let the prosecution know, and then that was an oversight. And if the court wants to sanction them, that is up to the court, pretty much. This court does not like the defense team. We have seen it many, many times. Let's go back to the video we were watching with Judge Bev to see some of her behavior towards the defense in the past while we wait for this beautiful, beautiful sidebar. And play.
Always is in Massachusetts. I don't care how it always is in Massachusetts. I care about whether or not it's appropriate.
Okay, it's appropriate. Okay, it's appropriate.
Make my argument
Okay.
to a law judge why it's not for a superior charge. They have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not
Okay.
she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed. They must decide whether she's guilty or not guilty. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jack?
I'd like an answer from the court. I'd like an answer from the court. I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty? How do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they?
Wow. Still disputed to this day.
Okay. And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty.
Yeah, but that's not what happened, lady. Ay, ay, ay.
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. That's how it is,
Okay.
Mr. Jackson. That's how it is, Mr.
Look
Jackson.
at her tone towards him.
That's how it is, Mr. Jackson.
That's how it is,
Apparently
Mr.
that's how it's
Jackson.
gonna be because the court told it. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option. For the subordinate charges, if they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. That's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this.
No.
Okay, okay.
I actually haven't.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option. I have not seen a verdict slip there where not guilty is not an option.
Okay, I disagree with you. All right, excuse me. This is funny, Ms. Reed. Excuse me. Excuse me. Excuse me.
Ay, ay, ay.
All right, we're done. All right, we're done. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor, excuse me, this is funny, Ms. Reed? All right, we're done. So, question, can we request the CERT report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. All right, we're done. All right, we're done.
Unbelievable. And what a big deal that was afterwards, right? Because the judge gave them a verdict form with 3 counts, but it didn't have the option to say guilty or not guilty count 1, guilty or not guilty count 2, guilty or not guilty count 3. It just said on top guilty, and then he had count 1, 2, 3, and they came out and said, some of the people in the jury came out and said, we decided, our deliberation and our verdict was that she was not guilty for both counts, but we weren't sure about the 3rd count, and that's what should be hung. But because the verdict form wasn't specific, they didn't know how to fill it out. The jury never signed the verdict form, and that became a big problem that was just appealed recently. And I believe that they lost that. So unfortunately, Karen Read now has to go to trial for all 3 counts again. And this is a huge oversight that the judge missed, because the judge didn't request a signed form, verdict form. She didn't clarify for the jury. She didn't make sure that their job as the jury of the facts was performed properly, right? She didn't facilitate that because she was so busy being condescending and aggressive towards the defense. We're done. What is this funny about, just cutting people off? And that's just not the right behavior, right? You have to be there. She calls herself the gatekeeper, right? I'm the gatekeeper. But you're not supposed to be meddling with things that are none of your business. You're supposed to be the gatekeeper. Make sure the process is being done according to the rules. And the jury verdict form should be signed. So that is on you, Judge Beth. Now let's go take a look at what's happening right now with the live court. There's still just the fan, only the fan. I'll show you guys so that you don't think it's me. Look, just sharing the fan here. So in the meantime, let's go back to one of my videos where I showed you guys Trooper Proctor, okay? So again, check out Bianca MMM and make sure you subscribe and you share and you give me a comment on this video. I love having you guys input, and every interaction helps the channel to grow. So here I'm gonna go to Bianca MMM, then I go to playlists and go to Karen Reed. Let me try to see. This is again the judge. I wanted to get like a small video on Trooper Proctor. I don't think I have a small video, but I'm gonna click on this one and try to find it in here because I know I made little videos on Trooper Proctor. So let's see. I think this is a part that I can. Oh wait, I think Court's coming back. Court's coming back. Never mind. We'll be back to this later. Court's coming back. That's the most important, right? Are you coming back, Court, or what? Just the fans, just the fans. Okay. Meanwhile, while they don't come back, we can't do it.
Mr. Lally, it's on there. Why don't you go show your witness? Why don't you just read it, Mr. Lally, and
Just
tell us who
read
you
it.
attribute
Who
it to?
cares? You don't know how to do it. Just read it.
Question is that chick a smoke? Again, 4146 question mark. I respond EH. I respond again nutbag, as Chief would say.
Nutbag, as Chief would say. This is the trooper that was the primary investigator, the lead investigator against, well, he was the lead investigator in the Karen Reed's trial. Okay, so he's supposed to be the lead investigator, making sure that all the investigation is properly done. He's texting his buddies. Is that chick a smoke? Kind of a nutbag, like Chief would say. These are his text messages, being publicized during the trial last year for Karen Reed, and he's obligated to sit there in court and just read his words. Wow. Now hold on. Who thinks the chief he's talking about here is Chief Berkowitz? Because that's what happened. That's what crossed my mind. And he was like, "Oh, Chief is just a friend of mine. Like that's just something, a nickname my friend has." Let's watch Proctor be remorseful to the jury.
Comments I should not have made. That I'm not proud of.
Sidebar. Sidebar. I don't know, sir. I need a little bit more. A little bit more remorse, please.
These juvenile, unprofessional comments have zero impact on the facts and the evidence and
Liar.
the integrity of this investigation. They said these are unprofessional comments, but they absolutely do not detract from the integrity of the investigation or the facts and evidence of it.
Your Honor, may I approach this retrieve?
Yes.
What are you referring to in that text, sir?
I'm referring to the arrest after Ms. Reed was indicted by the grand jury.
And again, as far as the terminology that you use in that text message to your wife, why is it?
Again, unprofessional messages I should not have sent. I don't have an explanation other than they're regrettable and something I'm not proud of, the language I used.
May I approach the retrieve, Your Honor?
Yes.
Oh, second, text communications among your friend group. With reference to that particular time frame and the language that you used, what sort of information had you gathered to that point, and why would you say or use that particular language particularly in your descriptions of the defendant?
This is, 16, 18 hours later. And we I conducted multiple interviews. We
Speak up.
conducted multiple interviews. We knew Mr. O'Keefe never went into Fairview Road. We knew there was one shoe at the scene, one shoe at the hospital. Based off Mr. O'Keefe's injuries, Ms. Reed's statements when Sergeant Buchanan and I interviewed her, her broken taillight, the missing taillight, some taillight pieces found at the scene led me to make those comments. Whether, like I said, they weren't professional comments, but based on the day's investigation, it was clear that Ms. Reed had struck Mr. O'Keefe with her vehicle.
Sir, if I could turn your attention to the documents before you, do you recognize those?
Let's do a pause here to go over some of your comments too. But it's like, to me, it sounds like a script. Hold on, let me see more of Trooper Proctor. Do we have any more videos of some of the stuff that he said? Let's try to go this way.
Kukowski.
Kukowski.
Tell me that again.
Kukowski.
Kukowski.
Yes, sir.
I love saying that name.
And you were bragging to all five of them
Kukowski. Sorry.
that you were going through Karen Reed's cell phone about 9:45.
Oh, looking for nudes.
I'll allow it.
Is that right?
No, I wasn't bragging. So going through his retarded client's phone right now.
You were shown a photograph of my colleague, Mr. Yannetti, correct?
Yes.
The copy that I was going to use.
Oh, I thought I gave him that to you.
Document that you were shown, copy of the same document that you were shown by Mr. Yannetti, correct?
Still Lally.
I've done that twice. Mr.
Don't
Lally.
call you
Correct.
Natty Lally.
Yes.
Excuse
That's Mr.
me.
Moore.
Okay, any objection?
Yes, Your Honor.
All right, I'll see you with that on there. Have that.
Yes.
You.
Trooper Proctor,
I am not Trooper Proctor.
Trooper DeChico had sent you a photograph
So
of
funny.
my colleague,
So
Mr.
funny.
Yannetti, correct?
Yes,
You see that, gentleman?
I do, sir.
Is that the photograph that you received?
Yes.
Is that what you referred to on direct examination with Mr. Lally about receiving a photograph from Mr. Yannetti?
Natty's like, pull up, KO, I'm right here. Tell it, say it to my face. KO. Sorry.
Correct. I hate that man. I truly hate that man.
How about you, Natty?
Actually, your response was, I'm going through his retarded client's phone right now, correct?
Yes, after the picture, sir. Yes.
Who's the retarded client?
I was referring to Miss Reed again, unprofessional language.
I'm asking who you were referring to.
Miss
I know
Reed.
You got an explanation. Who was it you were referring to as retarded?
Miss Reed.
Karen Reed, the woman sitting to my left.
Yes, sir.
The subject of your investigation as a professional, correct?
Yes, sir.
As an unbiased, objective investigator. The person that you were investigating, you referred to your bosses as retarded, correct?
Again, poor language on my part.
Poor language is one way to put it. Completely offensive is another way to put it, right?
Objection.
I've got to sustain that, Mr. Jackson.
I hate that man. I truly hate that man.
I hate that man. I truly hate him,
Mhm.
correct?
Correct.
Objection.
Sustained. You can ask it differently.
Sure. I feel about it now. I'm sitting right there.
I still don't care for him. No.
I'll let it stand.
They knew I was going through location data, text messages, Google searches. But like I had mentioned earlier, I had to stop.
Except Trooper Proctor,
I am not Trooper Proctor.
none of that really professional sounding stuff ended up in your comments to your bosses. What did you write after you talked about going through the quote retarded client's phone?
Objection.
I'll allow it.
No news so far.
No nudes so far,
Mhm.
correct?
Correct.
You were looking for naked photographs of Miss Reed on a Wednesday night as you sat in your office at 9:44 p.m., correct?
No, not correct.
You were supposed to be objectively investigating. Does your text message to your colleagues at Massachusetts State Police reflect an objective investigation of a citizen?
Objection.
You can get part of that question and ask it again.
She's like, ask it again. Go.
That your text messages were reflective of an objective investigator.
Objection.
I'll allow that. Do you believe that, Trooper Proctor?
I believe poor jokes have and unprofessional language have no bearing on the integrity and the facts and physical evidence of this case.
It's not that they don't have any bearing on the facts and integrity, it's that they have no place in a professional investigation because it shows bias. You weren't so much as objectively investigating Karen Reed as objectifying her, correct?
Objection.
I'll allow that.
Isn't that right?
Rephrase the question, please.
I
You
don't
weren't so
understand.
much as objectively
I don't
investigating
understand
her
the question.
as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke that I should not have texted out, but from the start of the investigation. We don't know what we.
Mr. Unetti, didn't it?
Objection.
Allow it.
He did, sir.
After you received the photo, that's when you said, I'm quote, funny, I'm going through his retarded client's phone. Is that right?
Objection.
Allow this, but not too many more.
Sure. Is that correct? It's on the top of page
Yes, sir.
685.
That's correct.
And your Buchanan liked that comment. Funny, I'm going through his retarded client's phone. Didn't it?
I see you laughed at an image here, sir. I can't tell if he.
Pull up
Like that
now.
comment, sir.
Laugh now.
Trooper Proctor, this is your direct chain of command. Is that right?
I am not Trooper Proctor.
You're Buchanan.
Yes, sir.
Did you believe that your conduct was a misuse of your authority and power as you were going through her phone in August of 2022?
Objection.
Allow it.
Yes.
No,
Yes.
I had a warrant signed by a district clerk, Stoughton District Clerk, to go through Miss Reed's phone. I don't think it was an abuse of power. I had every right to go through that phone.
Did the warrant say anything about looking for news of my client?
Objection.
Did it?
Did it
No,
say anything about that?
no, Your Honor.
Did it say anything about nudes, Your Honor? She's like, I don't care. She's like, let it burn today because I don't. And I think not today, but the second day he testified, he was saying something to the judge. He was like, whatever, ma'am. Like he didn't call her Your Honor, and I don't know. I like the judge on the day that Proctor testified, but then that's it. I'm back. I'm back to the, she's way too hard on the defense and not so hard on Lolly. Let's see here what you guys are talking. You guys are talking about something that I don't know, the inverted video. Okay, so yeah, back then we were talking about the inverted video. We're talking about what Trooper Proctor's testimony was like and all his opinions that came out to the world to see. So how I can't use the words I want to use, but how scary it is, right? To have that type of mindset, to have that type of language being used against people that you're being paid a hefty salary to protect and serve, and then you treat the community like that. You call the lady all kinds of bad names, you call the attorney all kinds of names, and then guess what? You're found out and you have to come and testify. So we're still on a break. We're still waiting for the OnlyFans. I mean, this is the shortest, it says short break, so I said shortest, but this is the longest short break in history. So we're going to look for, let's see, another portion here. Let's see if we can find some of the inverted video. I want to talk about, let me see if I have a video here about the inverted video, because that was crazy that they had the inverted video and we just never really got any sanctions or anything done against the prosecution. Wait, I think they're coming back. They're coming back. We're back. Yay! All right. Yanetti's supposed to talk, right? I think so. Let's see. Wow, come on. Sidebar. I was so excited for a second. This should be quicker, hopefully. So let's look at this real quick while we're waiting for them to come back. This is Trooper Buchanan's testimony. And he said that he kept going to the scene and the evidence presented itself. And then we also have here the SUV in the Sally Port. Okay. So we got all the evidence that he came to court to talk about the driveway of the SUV. This is Karen Reed's SUV. I want to see where the Sally Port video is inverted. Oh, this is a good one too. It's the SUV. Karen Reed's car was here, and they never took a picture of the taillight that supposedly was damaged, which was the right side. So they had this evidence, but they didn't bring that. So that was also surprising. Why didn't he take a picture of the damaged taillight right here? If she hit somebody with her car and the taillight broke into little pieces, why don't we have a picture here? And on this picture on the bottom, it looks like the taillight is intact. Let's see. This is the video of Carrie, I think, arriving at home. This is how many drinks they counted that she had. And then, yeah, I don't have the Sally Port here, but this was right before Trooper Proctor's testimony, and we had fun. We had a lot of fun. If you guys haven't watched these videos that I did when the trial was going on last year, please go back and watch it because they are very fun. We have like all kinds of awesome videos about the body language during the trial, how people were acting. Let me show you guys. We have Brian Albert. This was a great video. We got lots of views. This is at the end. Closing argument.
Grows over time.
This is Brian Albert's reaction during the closing argument from the defense. He was so nervous. He was so nervous.
And that, folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie.
Pause, Manny.
Over and over and over, they and others were caught deceiving big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left.
Whoa!
They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? Well, let's count the ways, shall we? Before your eyes. So how does a cover-up happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep them close. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. hide personal relationships, make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But most important, pick your patsy. What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative? It looks a lot like this. Because Karen was too kind, too nice, spoiled them too much, illustrated what anybody could imagine is a normal set of ups and downs for any couple. They talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the video. What are the words that every single person who testified in this case used about Karen Read and John O'Keefe that night? If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly. No, he never went in the house.
Okay, I hear the court. Hold on, let me go back and share this. They're back. Where's Yannetti? Here you go. Yannetti. Let's go, Yannetti, let's go.
Remaining argument that I can make in.
We did that because that was material that needed to be done at time.
Oh, I understand, Judge. And I'm
Just
thanking.
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement? And what was the date that you all found out about what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. Just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay. Any follow-up, Mr. Brennan?
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond, Judge. I'd like the court to take a particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response.
Yay, we have a motion response finally. What is it? What is it? What is it?
Amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and
Oh, we want to know real
the
motions.
Commonwealth's opposition. I would like to hear that now. We need to give them a minute. The parties have any problem with hearing that motion now? It is a
No, Your Honor, I think it's very brief.
motion.
Why do we keep going backwards? I want to know about the sanctions. You just came from a break. Do you need another break? What's going on, Bev? Sometimes it's not easy to keep the excitement going with court. You know, it's like scheduling this and I'll respond to that later. And we want to know about the sanctions. What do you guys think? Please put it in the comment. What do you think Aunt Bev wants to do? She wants to kick Alan Jackson out. She doesn't like
So
him.
you're both prepared to argue this motion?
But that is a big thing for her to do.
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak with counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G.I.A.
You still can't say Buchanan.
P-I-E-T-R-O.
Buchanan.
And 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos and then about another 15 actual videos. I basically,
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was,
Your Honor, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves, dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close.
It's like,
to
I was
close,
tired, Your
I
Honor.
have overnight this evening.
I was
I think I'll be
tired.
ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just want.
No, I want to know about the sanctions.
Position on Ms. Little's, or I assume it was Ms. Little's motion filed by Ms. Little motion to reconsider my previous ruling on the videos. Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue.
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sallyport video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today.
What?
And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Ms. Gianetti after 5:30 one night.
Whoa.
So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Carlos response, any idea?
Of argument time, Your Honor?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Of course, yes, I believe we will, for sure.
How does that schedule work?
It works for the Commonwealth.
I need to ask this one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just go do that
Thank you.
and not have to come back here.
Yeah.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can get to do it. That's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Canton PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion was just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
We're gonna be a couple of days.
Okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our time.
Right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that now.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions and we meet on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need something, right? I need to know by Thursday. It doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline?
Whoever's typing in the court or doing whatever, please stop.
How
Stop.
this disclosure of, this late disclosure of videos,
Sure, we'll deal with it.
all right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll run a supplemental very quickly thereafter. I have to decide this and put something right. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute?
All right.
So apparently we're not going to hear about the sanctions or the possibility of Alan Jackson being being excused from this case.
Your Honor, given what Mr. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever.
Don't take
But
him
I
for his
ask the
word.
court, if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow.
For what?
I will concede.
This, what?
The motion to dismiss.
Ooh.
I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang up is.
Don't accept his representation as true.
All right. Ms. Little doesn't look through.
She's like, what about what I just said?
Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental.
But you just said you didn't need enough time, more
I
time.
will be ready to argue tomorrow.
Okay. What's the
All right.
position?
I'll defer to the court. I know it's more complications with the defense and travel will be available when
So I think we did log off today and tomorrow with the understanding that the defense team would not be here until sometime 11 o'clock or later. What about Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on
I
Friday,
just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. And Mrs. Little will handle that's her motion anyway.
I greatly want to accommodate the defense as we have the entire time I've been here, but we have trial practice.
Shut up.
The more court hearing days we have hours of conversation, the more time we can't meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
all right, so Ms.
No, you
Little
don't.
filed the
No, you
motion.
don't. Don't lie.
We need to reconsider, why don't we hear that tomorrow as well?
Very well,
Okay, and then we'll just finish up everything tomorrow.
very well.
All right. All right, and then you won't have to be here Friday, but the motions in one are all filed. It also involves filling out a trial conference report. So
Understood.
you need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing, I believe it's the 18th, the motions in the minute.
That's right, the 18th.
All right, so we have a whole week next week to, you and I both, try and get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the
Motions in the minute.
Commonwealths were due on, the defense were due on Thursday, Commonwealth's on Friday. Or they all on Friday.
Reciprocal discovery is due Thursday. We want that to happen. Motions eliminated, we could do Friday.
Ms. Little, would you like the weekend for all those motions eliminated?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motions eliminated to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for,
Dr. Wolf is a neurologist. So there's
oh,
one
I thought you
additional.
meant, I was thinking the archivist.
No, Your Honor, it's the neurologist of the Commonwealth. Wolf without an E, WOLF. That was filed, 2 weeks ago, I believe.
I have not seen that.
Sounds like your problem, right, Judge?
I'll
Sounds.
make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a wolf as well, and I received their
A wolf.
motion, and we'll be prepared anytime to argue that.
I want to have a wolf.
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow.
All right. What about the sanctions? What's going to happen with that?
If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
Okay.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just don't contact the clerk's office.
Sure.
Okay. Anything else for today then?
I guess not.
Not for the defense, Your Honor. Thank you.
So I'm gonna give you all why don't you fill out all the percent of the application?
So that's it. That's it. All right. Goodbye. 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 Goodbye, Judge Cannoni. Cannoni. So we didn't have any results regarding anything today. And that is not surprising because we're here. We live in Boston now. We're in Massachusetts, and we're just going to live here for now because the Karen Read trial is the trial that never ends. So I want to thank you guys for watching. I'll do a quick recap. If you've never heard of the Karen Read trial, I don't think I can make a quick recap, but let me try this. This is something that I think it's actually funny. Like when people ask about this trial, they're like, what is this trial about? I'm like, okay, so Karen Read is a woman that was dating this guy, a police officer called John O'Keefe. one day, they went out to a bar and they had some drinks, and afterwards there was a party at another police officer's house, Brian Albert. He is married to Nicole Albert, I think, and there were other Alberts in there. And what happened was they had a German Shepherd dog, and the body was found. Mr. O'Keefe's body was found the next day outside the house of Brian Albert on the lawn, and it was snowing, so there was snow on the ground. People say that the next day Karen Reed was like, "Oh my God, did I hit him? What happened? How did he get here?" And other people like firefighters and it's so hard. Firefighters and other witnesses that came to testify said, "No, I heard her saying, I hit him 3 times." So because of that, she was indicted for the murder of John O'Keefe. But they say the defense claims that Brian Albert has been hiding what really happened that night, that maybe the dog bit John O'Keefe, or maybe there was a fight and they left him for dead outside. And he was a police officer. He never even went outside to check. Even when the cops were there, the firefighters were there, he didn't even offer any help, and it was suspicious. And then he had a phone call with Brian Albert. No, I'm sorry, with Brian Higgins, who is like another guy that works for the federal government. And then they deleted their phones. There was like a lot of butt dials. And then Jennifer McCabe, Google Haas longs to join the code at 3:00 in the morning. So we're here, and she went to trial last year, and it was a hung jury, and then the verdict form wasn't right because it never had the option for not guilty. And then the jury spoke out saying that they actually wanted her to be not guilty for 2 counts, but that there were 3 counts. And then the judge like, well, too bad, she's gonna be retried for all 3 counts no matter what. And then now we're back here for the anticipated retrial that starts in April 2025. And we're doing pretrial motions, and now the attorneys are fighting that there was an email about the ARCA expert. It's just, you better watch the whole trial. You better go to the channel. Like, my hair is like this when it comes to explaining Karen Reed. But today, what happened today, Bianca? Can you focus? Okay, I can focus. We talked about one motion, defense motion to exclude Dr. James Crosby. He's a canine behavior consultant. The prosecution wants to bring him in to say the injuries in John O'Keefe's arms were not dog bite marks. The defense in the past had brought Dr. Russell, who will come back, who's extremely qualified to testify about the bites that are highly likely to be a dog bites. Now, if it is a dog bites, guess what? It can't be that the car that Karen Reed hit him, right? So that's one, and that didn't go anywhere. It was just like an argument by the defense, then an argument by the prosecution. Then they talked about a second defense motion to exclude a meteorologist that is going to be called by the prosecution to testify about the soil, how hard the snow was, meaning, I don't know, he hit his head or he hit his arms, and that's how he got the injuries. So the defense has a problem with that as well. And then we had the prosecution motion for sanctions, which is why we were here today, about an extrajudicial statement, the defense comments and disparaging witnesses and going on the media and doing interviews, and they want a gag order and all of that. And that didn't go anywhere because in the middle of that, they had a break, and then they had a motion for scheduling the motion to dismiss, which probably is going to be heard tomorrow, March 5th, after 11 a.m., when the defense counsel comes back from federal courts. Get it? Got it? Got everything? So we have a lot, but we have nothing. And at the same time, I'm just so grateful to be back here on the Karen Reed trial, because we do have fun together. We make light of a very difficult situation. We know there are real people, there are real lives going on through this very difficult time on both sides, right? Karen Reed and her family, and also the victim family, John O'Keefe's family. So we send them our love, our peace, all the good things, prayers that we can. And I thank you guys for being here. We'll be here tomorrow again to see if they do anything interesting. We're going to have a super motion to dismiss. And guess what? The judge is not going to dismiss anything. So I want to thank you guys. Please leave a comment below, share, like, and subscribe to the channel. Mind, meditation, motivation. We have a lot of body language stuff on trials. We have a lot of different techniques for meditation, and we have motivation videos. What else do you need? What else do you need? Have a beautiful day, and I'll see you guys next time. Bye.